first. Welcome and thanks for joining us in today's panel on legitimate interest versus employee rights and data subject rights in HR data lakes. And I'm quite happy to join this panel as we have very esteemed guests. I think everyone knows Helen Dixon, who's probably one of the most renowned former data protection authority leaders in Europe. So she was the former commissioner of the Data Protection Commission in Ireland. I'm also happy to introduce Roy. Roy Kamp is a legal director at UKG, and Naomi Weinbaum, who is privacy lead at UKG. UKG is a cloud software solution for human capital management. My name is not Claude Etienne. My name is actually Paul Voigt. I'm a partner with Taylor Wessing in Germany, where I head the German tech and data team. And I was brought in really like a very, very last minute, like 60 minutes ago. So I'm as excited to understand what this panel is going to be about as and I was actually forced or asked to also introduce you to Paddington. Paddington will play a vital role in today's panel. Paddington, as you may know if you've seen the movies, has worked in a lot of fields. He was a window cleaner. He, I think, was a salesman in a retail shop. But what most of you won't know, because it wasn't in the movies, is that Paddington actually works for the London Public Transportation, and he's a bus driver, or he was a bus driver. He's worked as a bus driver for almost 20 years, and over time he made suggestions for improvement, what can be improved at the London Public Transportation, and he moved his way up. He went into office services, he was offered a management position, and not only because everyone saw the potential in Paddington, but also because they had a decent HR software, AI-powered, that actually found out that Paddington was designed for higher things. However, Paddington is a very creative and really nice guy, but can also be quite annoying. And when he found out that actually the reason for his promotions was this HR software, he got annoyed. Problem is that London Public Transport was not very upfront about using these kind of softwares. And of course, over time, you've seen a lot of data had been collected of Paddington. A lot of data went into a data lake, and so after 20 years' time, he's thought about enforcing a DSAR, so he wanted to get access to all of his data. Problem is, of course, the data is spread out everywhere, and in the data lake, you don't even know, is it Paddington data or isn't it? Yeah, because it is not clearly assigned to Paddington anymore, but with a bit of effort, you can find it out. A lot of questions are being raised by Paddington, like, is it even lawful? Can you use my data to put it into a data lake and to find out via AR whether I'm designed for higher things or not? Can I get access to all of my data even though it's potentially de-identified? Is this AI stuff, I mean, like, is it even permitted by GDPR? So a lot of questions that we're gonna speak about today, and let's start with the elephant in the room. Which is the digital omnibus that was basically just published minutes ago, and that's going to make all of those things much easier and much more difficult for Paddington. Roy, can you give us some insights into that?
Yeah, we spent a very frantic lunchtime today trying to read and understand what the omnibus says. As well as finding a 90th minute substitute for Claude. But a couple of things that we, specifically to what we're going to talk about today, are confirmed from, I'd say the leak is probably the wrong way to describe it, but the document that was leaked last week. So first of all, the personal data definition, the SRB decision is confirmed. From what we can see from a first read, obviously without any lunch and with quite a bit of rush job. That legitimate interest can be used as a lawful basis for AI development and operation, but obviously the balancing test and the three elements of the legitimate interest test need to be adhered to and complied with. The sensitive data definition is quite interesting. It allows for residual processing of sensitive personal data, especially in the AI context. But it does talk about you need to have technical and organizational measures to avoid, where you can, collection and processing. And if you can't implement those technical and organizational measures, then find a way to either remove the data or put in place some safeguard to protect the data from featuring in the output. And then the final bit, which is quite interesting, as a takeaway, and again, this is a provision, this is kind of a preliminary reading, that there is an unconditional right to object to legitimate interest as a lawful basis of processing for AI purposes. But then that raises the question, well, what do you do with the data that's already in the data lake? And then we get into I believe it's the CNIL guidance that came out earlier this year.
Yes.
That confirms, the omnibus confirms the CNIL guidance.
That's the feeling that we have is that it confirms the CNIL guidelines in the sense that it makes a difference between whatever happens in the input from whatever happens in the output. And so basically, from my read, from both documents and the omnibus, a very recent read, this truly means that we are given with the omnibus the right to forget the original sin. That's the way I would put it. So we are able to say, well, whatever you have done in the lake initially, let's forget about it, but let's make sure that the data subject already have truly a right to opt out of that processing if they discover that they have been part of the lake.
And so, before we kind of dive into the legitimate interest versus data subject rights, we thought it would be helpful to kind of give you some contextual slides. So the first one, actually, I think we can go through the full 2 cycles. Cycled away. So this is a general data life cycle, and there are many others like it, but this one is the one we've gone with. So you have on the left-hand side, you have the original collection, storage, use, sharing, transfer, retention, and deletion, and that's fine on its own. But then when you get to sub-processors, processors, and how they reuse the data, you then get that second cycle on the right-hand side, and so they tend to work. Normally, they tend to work in quite separate from each other, with the exception of that collection piece does connect from the left to the right. And then, in true movie fashion, to continue with Paul's analogy, we have 4 actors in this fantastic blockbuster. We have the employees, who are the data subjects. You've got the employer, who's the controller, and then you've got 2. We've separated them out for the purpose of the discussion because it does help to kind of understand that the employer might enter into a contract with the HR vendor or the SaaS HR vendor or benefits vendor, but those vendors may also have their own subcontractors, sub-processors to do other things as part of it. So sometimes the benefit vendor might be a processor, and sometimes they might be a sub-processor. So just bear that in mind from a contextual perspective. And then to kind of continue in terms of the context, so we saw the data life cycles. This is the employment life cycle and the HR data lakes. Because if you think about what goes into a HR data lake, it's everything that relates to your entire employment relationship with your employer. I'm not saying that everyone does it, let's be clear. That's not a statement there, it's just an observation that if your employer has a data lake, if the employer uses a vendor that has a data lake, then those are the 10 stages of your employment life cycle where data will be collected, processed, shared, transferred, and then once you get to stage 11, hopefully deleted at some point because you make a deletion request or it's no longer relevant. And then the final piece, or the penultimate piece of the context is the actual data lake itself. The analogy that I have to this is, for anyone who's seen the Simpsons movie, at the start of the Simpsons movie, if you remember what happens, everyone dumps trash, pollutes the lake, I think it's Lake Springfield, and then that causes trouble. And so if we put trash into the data lake, that will cause us problems from an analytics perspective, from a reporting perspective, from a compliance and all the other perspectives. So it's important that when we're talking about the data lake, we understand what data are we putting in there, how are we putting it in there in terms of, is it identified data, is it de-identified data, is it anonymized data if that's possible. And for those of you who are in Dublin in the spring, we talked about to what extent data can actually truly ever be anonymized because it's such a high standard. And then when we get to the final contextual slide, you've got, apologies, that's my blurry eyesight, you've got the two data buckets. So when you talk about the HR vendors, the service providers to the employer controller, they have two data buckets. The two data buckets are the service-related data that they need to operate the service, whether it's a payroll solution, whether it's a document management solution, whether it's a benefit solution. You need data in the clear to be able to provide that service to your customers. And then you have this comma, or the second bucket on the right, which is the product improvement. And we're seeing everyone talking about product improvement, AI training, and so there are different rules of engagement that apply depending on which bucket you're talking about. De-identified data on the right-hand side, whereas data in the clear, clear role-based access controls on the right, and very strict role-based access controls, and so on and so forth. And then the final slide is just to give you, and hopefully you can see it, the colors are woeful, and apologies for that. You've got, this is what looks like a de-identification process. And it's not anything special, or there are many other de-identification processes, but it's just to highlight the example that when you've got, when you de-identify and the names are taken out, and the names, the company details are taken out, you can still have a rich data set to be able to run analytics, to be able to say, like, I think the EU were talking this morning on their website about, or was it the other day, about the equal pay, was it equal pay day the other day? And so this can help you work towards your equal pay obligations, to be able to see what do the analytics say for equal pay without necessarily identifying employees in the data set. And I'll pause there and think.
Yeah, I mean, Roy, as you mentioned, de-identification can be a helpful tool, but maybe quite difficult in the HR space, because even if you take out the names, I mean, to go back to that slide, if you say it's a specific engineer, 23 years in tenure in a specific industry, or in a specific company, it may be quite easy to find out who's that, potentially. So that may mean that we still need a legal basis under GDPR for processing that data for secondary purposes.
Absolutely. So there are two things that I like about the previous slide, but we don't need to go back to the previous slide. The first one is that with 3 data elements in an HR data lake, you are able to re-identify 85% of the data subjects. So data in an HR data lake is so human that it's much more complicated than the garbage that we have seen thrown by the Simpsons in the lake. However, once we've said that, it's so human, it also means that whatever is in there needs to be processed with a local basis And that means that we are going through the compatible purpose under recital 50 of the GDPR. So it's not because it's in there that it's going to be a free pass. That has been like confirmed by case law constantly, and so really there needs to be systematically for each stage of the life cycle a review of the compatibility test and making sure that whatever the reuse is compatible with the initial process. And the biggest question is that we've seen that de-identification really helps reducing the risk and enables safe reuse, but we are also seeing that the purposes for which we are reusing the data is moving much faster than the definitions that we have of personal data. Although I should not be saying this today on the day of the omnibus, but Helen, I do not know what is your view on that, but I would love to have it.
Yeah, well, first of all, absolutely delighted to join this panel. My mind is already blown by the information you've conveyed, Paul, about Paddington Bear. Had no idea. What I was thinking when you were wondering about his data, I wondered whether bears from darkest Peru have rights under the GDPR, and I was a little bit concerned you were opening up to a future where AIs will have rights if furry, lifeless bears have rights as well. But as we're talking and going through the framing slides, perhaps it's just my background in regulation. I'm finding we're racing many steps ahead. And when you get to the part where you're talking about potential trash in the lake, well, of course, that starts with basics way back. And this is a fascinating set of scenarios that we arrive at today, because it seems to me this field, particularly of employees, employee rights, HR analytics, engages all of the most important areas of data governance and data protection. It spans all the different kinds of legal bases questions, impact assessments, contractual relationships between processors and controllers, controller to controller, retention and storage, as you mentioned, and then getting on later on when you've got the lake. So I suppose I found myself going back to the basics of the employer in the first instance, the typical bases they use of contract and fulfillment of legal obligations for the main collection and processing. But then you've got that question of additional, particularly now where so much is done digitally, that additional question of what can an employer also collect and process under legitimate interests. And in talking about all these questions at the end, we've really got to trace the employee journey from the beginning right through it, which I don't think any of you disagree on. And I was thinking, Roy, when you were talking about bias and avoiding bias, I was remembering some dignity at work training that I did in February of this year with my team at the communications regulator in Ireland. And the trainer who was training us gave us a very interesting statistic. He was talking about studies that have been done on performance reviews of employees that have looked empirically at them. And they looked at how many women get feedback in their performance review to the effect that they're a little bit strident or abrasive. And he said the figure was 70%. 70% of women get that feedback in some shape or form in a review. And then he asked us, how many men do you think get feedback that they're a little bit strident or abrasive or something similar in the review? Does anyone know what the figure is, the percentage?
0.
10%, he said. And I've looked up some of these studies. The figures vary, but the gap is the same, whatever study you look at. So of course, if you've got that kind of performance data in the controller's data set, it's accurate in that there the scores recorded. what does that do later in an analytics sense? So we've already a lot of biases that are human generated and there today that have to be accounted for and potentially corrected for later on in the data lake. So there's lots of other things I'll come in on, but let me hand back to you, Paul, so that you can direct a little.
Just very like a quick thought on that regard. I mean, we are very worried about biases in AI, but of course, at least we have the possibility to tackle these issues because we know there are biases in AI. We would know there are biases in every human, but to tackle these issues can potentially be much more difficult than looking at the AI, where I can make some tweaks here and there.
And that is true because that's where really we see the compatibility test under pressure. So typically, when algorithms are able to generate new insights and correlations that even the controllers did not anticipate, and I'm not talking about years, I'm talking about weeks, months, like this is going so quickly. Can we still use the term compatible? And does that mean that we need to change the way that we are doing those assessments and to move from something that is very static to something that needs to be continuously updated to make sure that the compatibility test is still valid and that those purposes are tracked and the lawfulness of those purposes are tracked as well. I think we can move to the other slide, but the feeling that I have is that the real pressure point isn't the test itself, it's whether human accountability can keep the pace with machine-developed technologies. So this is where we are, actually I think we can go to the previous one, we are really going to the GDPR's most fragile balance, like it's and the omnibus is going to confirm this basically, but there's a balance between legitimate entrance and the data rights of erasure and access, which is even more complicated when we are starting to talk about AI, because once the data has been put in the lake, well, technically speaking, it's very difficult to delete that data, even though we could eventually find it. Because it would mean that we would need to delete the whole algorithm and retrain it completely in order to be able to erase that data from the lake. So since this is not possible from a pragmatic standpoint, and this is where we are seeing also the political strike, I feel, between innovation in one hand and data protections on the other hand, how do we deal with this? So the omnibus answers clearly the fact that, well, we need to make sure that the data that's inputted in the system is as clean as possible and is of such a good quality as possible. Because whatever goes in, goes out. That's the analogy of garbage in, garbage out. And the second thing is that we need to be very pragmatic about this and keep in mind that if we cannot clean the data, the data lake, then we have to have the right mechanism in place to remove or put in place the right safeguards to avoid any sensitive information in the outputs, or to avoid output that is not of good quality, which goes back to the AI Act, which requires constant monitoring of the algorithms as well. So I have the feeling that DSRs are changing personally, and I have the feeling that we need to be very pragmatic about what we can do and making sure that we strike a balance with those data rights and do whatever we can to protect the individual and do it the right way. So we de-identify, for the lack of a better word, especially today, as much as possible this data, We try to make it as clean as possible. We try to avoid having data that would re-identify, which would reasonably re-identify an individual in the output. And then we need to be pragmatic about what are the rights that he can really have. I mean, we are not, as a provider, and I think as an innovator, it's impossible from an economic standpoint to just delete a complete data set. So the real thing is like, well, Paddington, I'm sorry, you're not getting your data deleted in the past, but this is only going to be workable as a solution in the future. And I don't know if, Helen, if you see this the same way, or
maybe rewinding to, you were talking about purpose limitation and compatible purposes and legitimate interests. And I think what you're saying is, and I agree with this, it's very important for the employer and the SaaS provider as processor that the employee is able to object or query the basis of the legitimate interests and get an answer that sets out why this is in the legitimate interests of the employer, why it's necessary processing. And I think the conversations I've had with the two of you, I've been very struck because, you know, no recent employer I've worked for has invested in this level of technology. They've been too small. But you've done a very good job in persuading me of the benefits to employees of the types of analytics and the security around the type of system that's in play here. So I think that's also important to be able to articulate what the benefits to employees are, what the benefits to individuals, and then collectively. I think where it veers into, I mean, I did wonder in thinking about it, could analytics be used, for example, to underpin the return to work mandates we're seeing now in some quarters and that aren't popular? So you may then get employees querying what data was used and analysed that gave the employer the answer that we're more productive back in the office. So I think it's where employees, of course, perceive that the analytics are leading to decisions that are adverse to them in some way, that you will start to get those questions. On the compatible purpose, I see some Irish colleagues in the audience. There's an interesting case in Ireland that I dealt with called Cormac Doolan versus the Data Protection Commissioner, and it was very instructive in an employee context. It's worth looking up on that question of compatible purpose, because the High Court in Ireland and the Court of Appeal found against my decision on the question of compatible purpose, and where processing had taken place of CCTV footage for a security and safety purpose, but later found its way into a use for disciplinary purposes. The court was very clear that it simply was not the same purpose and required separate communication to an employee. It didn't address the question of legal basis, but the court took a very harsh line on the separation of the purposes. So I think you're right that that's an area that is always going to be in very, not so much delicate balance, but is going to require very fine analysis to conclude that purposes are compatible.
And one question maybe with respect to compatibility in the age of AI. AI is a software that takes decisions autonomously. So I can't plan ahead, but whatever the AI is going to do is to some extent not in my hands anymore. Does the concept of compatibility of purposes even properly work anymore? Is that something where we have to rethink the concept maybe overall?
Yeah, and it may come back to the explainability and the transparency of what the AI is doing is also linked into that question. There was an interesting piece in the daily dashboard from the IAPP yesterday that was talking about inferred identities, and it was asking the question about whether we're going to need collective rights to challenge processing of data as opposed to an individual right, because it was looking at how perhaps something could be inferred about my identity based on processing of data from my near neighbours in terms of where I live and so on. And I think all of those questions start to come in here, and there's no automatic or neat answer to them. There's just a need to proceed with such caution, because nothing is more personal to any of us than how we earn a living, how we dedicate our time and energy every day in our workplaces, and the stakes are high.
Just out of curiosity, in going back to the lawful basis of processing, how would you, if you think back to when you sat in the regulator chair, obviously in the employment context, there is the imbalance of power between the employer and the employee, so consent is not a usable lawful basis. Would you say that in the employment context, the balancing test needs to be applied even stricter when you're relying on legitimate interest because of the risk or because of that imbalance of power?
Oh, I think definitely when you get to the balancing test, the rights of employees, the importance of being able to work for everyone and work in a way that respects dignity and isn't overly invasive in terms of surveillance and monitoring. Yeah, I think that's a test where the employee has a lot of rights on their side of the equation and a lot of interests that need to be reflected when you're documenting the balancing test as well.
Okay.
I mean, it's not impossible, but you know, for example, all of us presumably process CCTV of employees, where CCTV is catching employees coming in and out of the buildings, but it's there primarily for security purposes. So there is always a certain amount of data that's processed almost with less question of employees, but it's as the impacts grow greater and the downstream analytics, I suppose, can start to surface some of the effects of the collection of that data that we're unaware of now.
So that's really interesting. So we are moving to what I would call the anonymization marriage, and so that's really it's the origin of the sin. That's what I call the origin of the sin most of the time. So the origin of the sin is truly if we are able to de-identify data as much as possible, will we be able to have a clean HR lake? But as I was saying at the very beginning of the session, with 3 data points in an HR data lake, you're able to re-identify 85% of the individuals. So with that type of figures in mind, I feel that anonymization, which is like the impossible quest basis for privacy professional, is even more true in an HR data lake. And so it's truly, anonymization is rarely going to be absolute. And so there's an idea of, well, it's not only going to be rarely absolute today, but on top of that, with technology, with AI, whatever is anonymized today will most probably not be anonymized in a couple of years. So that's the point where we were asking ourselves whether we should not, by default, consider that the data is pseudonymous, it's still subject to the GDPR, and take it from there and apply specific technical and organizational measures to protect that data and be transparent about it with our users, which I still feel is the case, even though the omnibus is telling us that there's a way out of there. And even though with the SRB decision, which decided that data can be anonymous for one party and pseudonymized for another one, is still questionable. And that's where we are getting into a very interesting question, I feel, about what is the future of AI training, and whether or not we could be using data custodian or data stewardship schemes whereby we would enter into a controller-to-controller relationship with a third party who would be anonymizing the data for us, keeping the key of that data with them, be able eventually to answers to those DSARs, since they would have the keys, and would enable a safer way of doing AI training. And so that would help, I think, to move from something that is complicated, because privacy enhancing technologies are very elegant, I feel, but this is like, it's not a miracle solution. It's not like you're buying a solution, this is it, end of the story, I've done it. It really requires strong governance principles, and one of the first governance principles that I see in that scheme is that there needs to be a segregation between the parties. So, so truly that cannot be achieved if everything is done internally within one organization. And I do feel that even if we have if we put in place an organization where we have a specific subsidiary handling the anonymization, would that be sufficient? Or would the segregation controls that we have under the ISO 27001, for instance, would those be sufficient? How do you see that, Helen?
Yeah, I mean, I would agree with you, and looking at the de-identification sample, Roy, you put up earlier, at best it's pseudonymous. You're not going to achieve anonymization, so I would agree with you. You need to be considering that it is personal data that's being processed, and it has to be handled accordingly. In terms of using a third-party trust, that could be a solution in terms of pseudonymizing and then suggesting that in-house you now have no means, because of a contractual relationship with an independent trust that you've put in place, you've irrevocably given up the means to identify. So that's worth exploring. The other legal solutions you were talking about subsidiary companies and so on, again, you'd have to look at the specifics. They seem a little bit more doubtful when the crunch would come as to whether they would really demonstrate the necessary level of independence. The other thing I was wondering about, and a question for you as you were talking there about the AI model and running the model, is whether the SHUFA case is also relevant to the type of analytics that we're talking about here, because of course that suggested that the credit scorer, even though they're not the ultimate decision maker on credit, is also bound and caught. Do you see that? Do you see SHUFA as something that would bind what you're talking about here?
Yeah, go ahead.
Well, yes and no. Yes, in the sense that if SHUFA is followed to the letter, then there needs to be human in the loop. And I think if human in the loop isn't if you don't have a human in the loop as part of the process, then I think it does trigger a greater issue. Because if we don't have the human in the loop, the decision making, you're just accepting the decision making, whether it's the analytics of saying, fire that person's performance isn't great, reduce their pay, promote them, etc. So I think the human in the loop piece comes in quite heavily on that piece.
even to the analytical results you would output.
Absolutely.
Before they're passed on to any employer
Absolutely.
to make a decision.
Absolutely,
Okay.
or at the very least, the employer should be making the decision, looking at the analytics and saying, "Ooh, we need to look at this because this doesn't track with what we're seeing with this employee, because it's pattern recognition, and that's where I think there should be some form of, I think human in the loop is, sounds silly to say it like this, but it is a no-brainer because it then addresses your Article 22 GDPR requirements. It addresses bias. You can look for bias when you have someone actually looking at the data and saying, or the analytics and saying, this doesn't look right.
For the Schufa case, I mean, one of the interesting parts was that basically we had two players, and the automated decision making only existed because you would look at the two players together. So each of them would not fulfill the requirements of Article 22, but both together would. Could there be an argument against some kind of agent that uses de-identified data in order to evade privacy? So under SRB, you could argue, I give all the pseudonymized data to a third party, and then they will do the analytics, for example, and would potentially not be bound by GDPR. But can I argue this way, or do I have to look at both players, knowing that the one actually involving the agent would have access to the data? Will I have to take a look at both parties again?
I mean, my reading of Schufa is that you would, that the analytics is the equivalent of the credit score, and even though they ultimately didn't make the decision, the fact that there was significant reliance on what they produced, that was an automated decision effect for the purposes of Article 22. So I think there would be that complication there. But I could be wrong. This is very much a new area, and as I said, it's a fascinating and very important area because it engages the state-of-the-art case law and thinking we need to do around these types of questions. Maybe the audience knows the answers.
maybe I open it up for questions. So we have still a few sides and a lot of things to speak about. But are there any questions from the audience? Is there someone with a mic, maybe?
It's coming.
Someone's coming, but you can already start screaming.
Can you raise your hand? Thank you.
So in the recruitment, recruitment case, if we look at ranking candidates using AI to rank applications, then there are a lot of other steps that follow, through the interview with HR, with management. So there is the human factor there. So there is somebody that checks, but still the simple fact that you rely on a ranking, if you have 300 applications, let's say, it's a huge number, but even if you have 50 and you're a small team, you will rely on the result AI provides you. So in that case, is it or not considered as an automated decision? Because I see a lot of companies say no, because we have, HR comes in afterwards and the manager, hiring manager and everything, then it's not. But still, the starting point affects the whole decision.
Who wants to answer?
I think for me there's a step before, because if you've got 300 applicants and you've got AI ranking, that also means that you're excluding 150 maybe that don't even get to speak to the HR, or to the hiring manager. So I do think that there is. Does it trigger the requirements of legal effect or similar significant effect of Article 2022? We did talk about that the other week, and I think there is I could see somebody trying to construct an argument that it does, because it prevents them from getting a livelihood. I think it's a bit of a stretch, though. It's constructed, but
It's funny, this must be a topic that's exercising a lot of employers that are doing a significant amount of recruitment, because I participated in the IAPP run this morning, and this was the entire topic for the hour that I was engaged in, and you know, there seem to be some creative / cynical suggestions that post the ranking by human dipping in and randomly picking some that are beyond the cutoff in the ranking that are going to be called for interview would bring in human decision making. Now, look, I certainly wouldn't condone that kind of cynical approach to it. I don't know the answer, and I think there isn't a clear-cut answer, was the conclusion I came to having chatted it through this morning. There is an argument to be made that it is automated decision making and it's automatically excluding, and then equally, as you said, you could argue that there are substantive other elements in the process. So I suppose, as Roy said, it may depend on where the ranking comes in, where it's situated in the decision making chain. You probably have a perspective on it yourself in asking the question, so.
I'm just curious if you have any suggestions on how to set it up. Because I think it does rely a lot on how the ranking is done.
Yeah.
Because if it really looks at, you know, number of years of experience, then that is pretty clear. But if you have a certification.
Oh, absolutely. Deterministic filtering, absolutely fine. That's not an issue. Yeah, you're absolutely right. But ranking that is not just deterministic filters based on published criteria for the role about years of experience, that's what I'd understood you were talking about, and I think that's when you're into the very grey zone.
Yeah, I think my concern was in our case that the vendor didn't have a clear explanation on how the ranking was done.
Yeah.
And I think that's when you start thinking, okay, but is it something that we can go back to and explain and show how we avoid bias, for example? Or is it we just trust them, or they're worried that there's no bias? And so it's, yeah, I'm just trying to figure out from a advisory perspective, how do we advise our HR teams? What are the questions that we can ask the vendor, or what are the extra steps that we can put in place to make sure that the ranking does avoid the it's only interpretation or it's only
Yeah.
So if I may add, when I'm listening to you, the feeling that I have is this comes back to selling an axe. That's the selling an axe analogy. It's not because as an HR provider we are selling you a tool that you will not be using that tool as an axe and go and kill someone, although it was not intended to be sold to kill someone, but it was intended to chop some wood. And this really comes back to the same idea, is that vendors will have like AUP, like the authorized usage policy of the tools. You will have like terms and conditions that you've all seen, that you're not supposed to be using those tools to go and kill people, for instance, or do something else. But truly, it's up to the customers to have also in place the right ethics to be using AI in an ethical manner. So it's something that I feel that as a vendor we cannot, we can only enforce bias to a certain extent. And then it's also the role of the customer to make sure that it's using the tool in the right way.
Naomi, a follow-up question in that regard. Is there a shift to how you consider yourself as a vendor, taking into account the upcoming AI Act, where basically as a data processor under GDPR, you can, a lot of burden is of course shifted to the controller, despite the fact that the vendor provides the actual tool, whereas under the AI Act, the vendor is actually the one responsible much more than the controller. with respect to bias, with respect to how the system is set up, with respect to explainability?
So, I think that there is, to some extent, a certain shift, in the sense that we would act as a controller for the second, if you remember the life cycle, the life cycle where we actually process the data for AI training, for developing new functionalities, for getting insights from the data. That's really where we would be, where we see that we are more acting like a controller. In terms of the first cycle, where we provide really the solutions to our customers, I do not see why we would not be acting as a processor. Of course, there are some like specific cases where we are a controller because we have a direct relationship with the data subjects, but that's really in specific cases. But it's a little bit a case-by-case analysis as well, if I may say.
But I think and I might be shooting myself in the foot here in answer to your question, I think there's a vendor management aspect to this. Because when you're buying in a solution, hopefully you have a clause in your contract, or the vendor has a clause in the contract that they will comply with the laws. And explainability is part of the AI Act, part of the law that applies. So if you're not getting the answer that you need to press them on that compliance with, kind of using that compliance with law clause to get the answers that you need. And it's in their interest as well, because if word gets around in the market that they're not giving you the answers, then they're not going to sell very much.
Yes, I want to continue on the first questions because I think it was interesting, and your response to that, Helen, perhaps you could elaborate, because and I think we're not really distinction between automated decision making and using AI for recruitment, which is a high risk. I think they're two separate, because automated decision making is agnostic to technology. You may be using AI or not. You could be discriminating by using filtering, as she was explaining, like exclude all women. That's the discrimination, right? And it would be automated. So that would still fall within the automated decision making, Article 22. Would you not agree?
The filtering, I mean, great idea to exclude all women, get rid of those
No, because we always talk about like AI
to a
discriminating.
winner there, that would definitely be lawful. Let me think, so you're saying would the deterministic filtering be automated decision making? I don't think that would. I mean, I think that would be the equivalent of a manual process where I publish that I'm recruiting someone who has an engineering degree, a civil engineering degree, and is 5 years post-graduation minimum experience, then I think it's perfectly legitimate to filter out anyone who doesn't have an engineering degree, for starters. That's not an automated decision making, it's simply sorting based on published criteria for the role.
So this is what I'm saying, like the automated decision really doesn't take into account the technology that you're using. It's really automating that work.
Yes.
So even it's usually manual work that is done by someone, that the fact that you're automating it, you're removing the human from the work. That's what Article 22 is about. Maybe that's just my misunderstanding of this.
Yeah, I mean, I have to say, I never understood it as signifying that if you were simply screening out based on pre-set criteria, that was decision-making that has a significant effect. It's process. But look, I'm open to others disagreeing on that.
The reason I'm thinking about this is because the AI Act goes into, the job posting, the filtering part, and puts those as high risk because they do have an effect. So that's why I'm bringing in that type of thinking in the e-recruitment, which is in the recital of the GDPR.
Yeah,
and just
but of
elaborating
course it's
on that.
about AI systems doing those things
Yeah.
is the key thing that's regulated. So, yeah, look, I'll think some more about it, but I wouldn't have thought that is automated decision making, that
Thank
type
you.
of.
I actually see it the same way as you, Helen. I think it's automated, but it's not decision making, because the decision, someone else took the decision. Someone else said, I only want engineers with more than 5 years experience, and then the automation just enforces that decision that has already been made. So like it's not the decision making that is automated, but just the process that assists in the implementing the decision.
Because expert systems has always been considered to be, automated decision making, and they are predefined. So that's why I think it's a bit, it's a bit contradictory what you're saying to what you've considered to be automated decision making, and what predeterministic AI systems even are, and then you now saying that it's not.
Okay, so then we have not one answer to this, but two. But looking for one last question, maybe.
Anyway.
Yeah.
Thank you. Very fascinating topic, and I wasn't expecting Shuva to be thrown into this debate. Also, disclaimer: I haven't read the omnibus, so the question may be outdated. But I'm just wondering, from a logistical perspective, Article 22, there's a data subject request requesting human intervention because the data subject is under the impression that the decision about recruitment, for instance, was taken in a fully automated manner. With Shuva in mind, who is on the hook? Who is to triage, respond to this request? Is it the deployer? Is it the provider? A combination of both? Do you have a clear position on that at this point in time? Or do you think there is uncertainty of this? And if so, what do you believe may be the future trends in this area?
Lynn, do you want to go ahead?
Well, as you asked the question, I was wondering, in this scenario, who is the provider and who is the deployer? And depending on the way it was deployed, I don't know, for example, your particular, UKG's particular version, could what you're considering, the employer who may be the deployer, could they end up being the provider depending on how much adaptation they can do? So I think an awful lot depends on the specifics of who is what, but maybe that misses the point of the question, which is how an employee concerned is going to be addressed. Is that?
Yes, a prospective employer would be the deployer, and system provider is the provider of the recruitment system being deployed by the prospective employer.
So you're assuming no
Similar to
adaptation
Shuva.
or significant.
I'm just starting an analogy with the
Yeah.
Shuva case, but in a recruitment context.
So I would always start with the employer, or the controller, or the contracting, the purchasing party. They should be the starting point, because you don't know, as a candidate, for instance, you don't know at that point who the vendor is that's supplying the applicant tracking system, the recruitment system, etc. So the first thing is go to whoever you're speaking to on the recruitment side and say, I'm not happy with this decision. And they should have a privacy policy published on their website, because that's what we're told that we need to do. So we publish privacy policies and give people their rights, and then we go from there. And then the employing or the purchasing customer then goes to the vendor and says, I've got this request, let's work this through, or how do we respond?
So it's a joint effort between the two parties.
But starting at the very top of the chain.
The first point of contact for the data subject. Okay.
So,
Okay.
so the data subject would go to the controller, and the controller would ask through its processors, please assist me with this request.
And that would be in your DPA as well, that obligation to assist.
Yes, absolutely. Thank you.
Okay, then we have 30 seconds each for the very last words. If there's anything we have missed in our discussion today, any questions left open, and also as an overall question, will the omnibus solve the issues that we have been discussing today? And I start with Helen.
No, it won't, because the problems we have today are the problems we had last year and the year before. It's getting the basics right. It's understanding what you're collecting, why you're collecting it, purpose, limitation, storage, legal bases, doing the impact assessments. It's getting all of those basics right. and that's hard, and we haven't cracked all of that yet. So the omnibus, which in any case has to go through a legislative co-decision making process, that is on the never, it isn't relevant today, I would say.
Thanks. So same. Roy?
For me, the two words that come to mind are transparency and minimization. If you can reduce the amount of data that's going into the lake, it's easier. Life is easier. I like an easy life.
Easy life, but I'm not sure that the omnibus is truly going to ease our lives so much. The feeling that I have is that legitimate interest is not a convenience clause, and it's not going to be a free pass to do whatever we want. And it sounds like simplification, but it's still going to be a lot of work to document this, and the work around anonymization and the risk of re-identification is still going to be very heavy and very dynamic in this environment.
Okay. Thank you very much for joining today's